Namaskar. This session I'm going to discuss and rather I would say read all, all the sections of the act and the rules. I have the videos on how to prepare for the patent as an exam. In that videos, I summarized everything and they are in the PPT format. Many times I have come across feedback that many of the students who are trying to prepare for the patent as an exam, they find it difficult to understand the language of the act and the rules. Therefore, I thought to prepare a videos on how to read and how to read and interpret and understand them. So this will help them to read themselves and prepare very well. So if you are interested in knowing the summary of all the sections with the form, fees, and rules. I have all the videos for all the session. But in this series, for preparation of patent as an exam, I'm going to read the patent acts so that you also learn how to read them. Once you understand how to read them, it is very easy, not a difficult task. So the first thing that we need to do is when we start preparing for the exam is to memorize this first page. You can you can open this page online. This is easily available. If you go to ipna.gov.in, this website is there. You can see and you can read this. There are certain amendments to this, and there are certain changes in the rules that I will tell you where it comes. And I hope you would also be knowing about what are the changes are there. So first thing that we do is to memorize this, and that will go a long way in helping you to understand and prepare very well. So you can start reading the table of content. Section 1, short title, extent and commencement. Section 2 is definition and interpretation. So this is chapter 1. And then section 3 is what are not inventions. Chapter 4, inventions relating to atomic energy not patentable. Section 6, persons entitled to apply for patents. So these are very sequence and logically arranged. So when you start, the first thing is that we need to know the definitions, then what is not invention, and who are the persons who are entitled to apply for the patents, then form of application, then section 8, information and undertaking regarding foreign applications. Then section 9, provisional and complete specification, section 10, contents of specification, section 11, priority dates of claims of complete specification. So in this way, I would request you to read and memorize all the sections. Initially, it may appear to be difficult, but gradually you will get used to it and you can memorize. If you ask me, today I don't remember all the sections which I did when I was preparing for the patent as an exam. But today I know which sections are where, and then I can always look it up and go and read them. But in due course of time, when you are daily working with the sections and discussing, then you can also memorize this. So everyone who passes the exam, be sure that they know these sections very well, and it helps in understanding the rules and also while answering many questions. So let us start today's session. So section 1, the Patent Act 1970, Chapter 1, Section 1, short title, extent and commencement. So it says this act may be called the Patent Act 1970. So it means whenever we are going to refer it, we need to say exactly like this. Patents Act 1970. This is how we need to refer to it. And section 1, subsection 2, it said it extends to whole of India. So there is no limitation in India, means whatever the parts is covered in India, states and geographical location, whatever is covered within Indian jurisdiction, everywhere this act is valid. This act is valid means what? The patents gives the right to exclude others from making, selling, offering to sell, importing, everything with regard to the patented and granted patent and active. Active means which are live. People having they are paying the annuity fees. They are not abandoned, so they are legally active, and one can enforce those patents in all the location in India, in all the states of India equally. Then section 1, subsection 3 said, it shall come into force on such date as a central government may, by notification official gazette, appoint. Okay. So what it means that central government time to time, they will pass a notification. So, and they will give a date from which date it becomes active. So they will also mention that what is this act will call. So they mention a short title by which this new amendment will be called, and it comes into force from which date. So that date will be mentioned. So it is given here so that in future, whatever the central government makes the rules or amendment changes are there, so that will also apply to this section. It says by notification official gazette. That means you will always receive a official gazette from Government of India saying that this act is valid. Let me show you one such. So if you see this one, patent amendment, if I open this one, you will see this notification. I hope you can see this. It says the Gazette of India, Bharat ka Rajpatra. And then it mentions Ministry of Commerce and Industry, Department for Promotion Industry and Internet Trade notification. Okay. And so similarly, you will get this notification, and then a date will be mentioned here. So this is what it refers to when you say by notification official gazette, appoint. Provided that different date may be appointed for different provisions of this act. What does this mean is that different sections, there could be one section is enforced from some date, another section for enforced another date. It is not that a government will pass one date and entire patent act is changed. It's not that way. But a different date may be appointed for different provision of this act. And any reference in any such provision to the commencement of this act shall be construed as a reference to coming to force of that provision. Means there are different sections are there, and for each section, there could be a date from which it will be counted, and we need to consider accordingly. I mean to say that for section 1 could be you can change a date, and then from that date, section 1 extend changed. Section 2 may change, similarly like that. Okay, so next we go to section 2. Section 2 is little bigger, and in section 2 you can see that there's section 1, section 2, then we say subsection of section 2. So this is 1, and then in 1 there are A, B, C, D. Then again in A there's A, B and A, B, A, A, C, and then B, C, D, and then you also have 2. So in subsection we have section 2, we have subsection 1 and subsection 2, only this much. And in subsection 1 there are many definitions are there. So subsection 1A, appellate board means appellate board referred to in section 116. Now this 116 is completely abolished. So this section 116 is not there. So this publication is older. So therefore they still have mentioned this. So this appellate board mentioned section 116. So section 116 is now cancelled. This doesn't exist now. Appellate board is not there. All the activity of appellate board is now with High Court. Section 2, subsection 1, and within 1 we have AB. So section 2, subsection 1, AB, it defines assignee. So whenever you are said who are assignees, very important. You will also get some questions, some multiple choice question on this. So assignee includes, okay, it is not talking about excludes. It's talking about includes means only this, assignee of the assignees. So if there is a assignee and if they assign someone else, they will also be called the assignees. And the legal representative of a deceased assignee. So if somebody, I mean, there's a legal representative, if after death, he has some legal representative of, so he will also be called as an assignee. The reference to the assignee of any person include references to the assignee of the legal representative. So when you say assignee, so assignee of any person include reference to the assignee of the legal representative. That means legal representative can also assign the patent to other person or assignee of that person. So in simple language, you can say that assignee, one person who assigned the first one, he's the assignee, his name is there. But if in future he assigns to someone else, they will also be called as assignee. So this definition, I remember in one exam, this question was asked, what is the definition of assignee? And some variation of this language was given, and we need to select who is called assignee. Then ABA. So section 2, subsection 1, ABA, Budapest Treaty. Budapest Treaty means was international recognition of deposit of microorganisms for the purposes of patent procedure done at Budapest on 20th day of April 1977 and as amended and modified from time to time. It means uh, there's a Budapest Treaty. We have to remember this date. This date may be asked sometime as a multiple choice question. And we also need to remember what this Budapest Treaty is about. So Budapest Treaty is about the deposition of microorganisms. So if our invention is with regard to microorganisms, then this Budapest Treaty comes into picture. So from section 2, subsection 1, ABA, we just need to remember that Budapest Treaty is with regard to deposition of microorganisms. And this was done at Budapest. Therefore, this name is Budapest Treaty. And the date on which it was done is 20th April 1977. Okay, then AC. So you can just memorize that AC, C means capable. So AC means capable. Or you can have your own way of memorizing this. But I just memorize by saying AC means capable. So capable is AC. So one of the requirement of the novelty is that it should be novel, inventive, and capable of industrial application. So what does this mean by capable of industrial application? So with relation to the invention, so it is only talking about the inventive part. So whatever invention we are claiming, that should be capable of what? Two things, being made or used in an industry. So it should be able to produce, it should be able to make in the industry, or that should be used in an industry. So being capable, it is not saying that capable of being made and used in an industry. Here you can see and is not mentioned. It says or, means this or that. It can be made in industry and used in industry. So a question may be asked, um, capable of industry application means capable of being made and used in an industry. So they may confuse you by writing and. So remember that this is not and, this is or. Capable of being made and used in industry is not correct, or it should be or. And is not correct, either of them. So any invention, it must be should be used in industry, or it should be able to make in industry. Then B, section 2(1)(b), controller. Controller means controller general of patent, design, trademark, referred to in section 73. Section 73 is on detail about the who is called controller and what are the powers of controller is mentioned there. So throughout the section, wherever this word controller is mentioned, we just remember the section 73 and the content. Convention application. This is one term, convention application. Convention application means there are few countries who consider the patent file in their country as patent file in all other countries. So these are called conventional countries. And uh, we can file one patent in India, and then we can reserve the priority date of filing in India. And from that, within 12 months, we can go in any conventional countries and file application. And those countries will respect our application similar to as they respect patent application by their citizens. So these are called conventional applications, and this is described in section 135. Okay. And similarly, convention countries. So as I said that C for convention application, and 1D is for convention countries. Means a country or a country which is a member of group of countries or union of countries or interdepartmental organization referred to as convention country in section 133. So this is mentioned there. So these are all the group of countries. So it could be means a country, could be one country, or a country which is a member of a group of countries. Okay. Or a union of countries, or an intergovernmental organization also. So sometimes you may be confused when it is asked that can intergovernmental organization be considered a convention country? So it is correct. It is mentioned here that convention country means an intergovernmental organization. This is also included. You may get confused because convention country and intergovernmental organization, they do not sound like similar, right? Convention country and this is an organization. So this may not sound similar, but this is also included under convention country. District court, it is very easy. District court, meaning as defined by civil code, a civil procedure, 9085 of 908. Exclusive license means a license from a patentee which confers to the licensee or the licensee and the person authorized by him to the exclusion of all other person, including the patentee. Okay, so this is very important. Exclusive right means it also excludes person authorized by him to exclusion of all other person, including the patentee. I mean, If you are a patent holder and you grant an exclusive right to another person, then you also lose your right to exercise. So, which right? Any right in respect to the patented invention. Okay. So, patentee has different rights. I mean, he can exclude other from making, using, offering for sale, and importing everything, and all these things he can ask other not to do it. Out of this, he can grant exclusive right for something. For example, he can grant exclusive right just for importing. Just for importing, he has exclusive right. It means only he can import. The patentee also cannot import because he has granted the exclusive right for that invention in that respect. And exclusive licenses shall be construed accordingly. Okay. Number H. So section 2, subsection 1, and then H. It is very bigger. It will take some time to read. So I will just read it through, and I hope you will understand this. Government undertaking. So government undertaking includes many things. Any industrial undertaking carried on by department of government. So in the other section, we'll see this word by government undertaking. So which are this included? So I think in one exam, this was also asked. Department of government or by a corporation established by central, provincial, or a state act, which is owned or controlled by government. So this is very important. Any department of the government, this is also called government undertaking, and any corporation established by a central, okay, or provincial or a state corporation must be established by these three entities: central, provincial, or state, which is owned or controlled by government, which either owned or controlled by government. This is condition. Or by government company as defined in section 617 of Companies Act 1956. So this you can read in more detail about it. And next is number 4, by an institution wholly or substantially financed by the government. So even if there is an institution which are being financed, so there is a word called wholly, I mean completely, entire funding is done by the government, or substantially. What does this substantially mean? Does it mean 10%, 20%, 50%, or more than 50%? So it is not defined by percentage, but it says substantially. So this need to be interpreted very clearly. So we can understand that for our exam purpose, substantially means if there are two parties, government has the highest share. I mean, their funding is more, and therefore their right is more. So basically, idea is like government undertaking means central government has the right over that corporation or entity or institution. They have the higher right to do something or to make a decision. Therefore, it says department of government or owned and controlled by the government, and then government company. Of course, this will be controlled by the government and substantially financed by the government. So anything the government undertaking means government has the control over the decision-making power. High Court, we understand this. State or union territory means High Court having territorial jurisdiction in that state or union territory, as the case may be. International application, IA. IA means international application. So section 2, subsection 1, IA is international application. IA, international application, easy to remember and memorize. As I said, AC means capable of industrial application. A means appellate board. AB means assignee. So Like that, we can memorize F means exclusive license F. And IE means international application. International application is what? An application of patent made in accordance with PCT, Patent Cooperation Treaty. Patent Cooperation Treaty. So those are called international application. This is also a question usually asked. And what is the invention? Invention means a new product. Okay, and this is a novel product or process. Product or process, new product or process, and also involving an inventive step. So there has to, it is a new, it has inventive step and capable of industrial application. So whenever it says capable of industrial application, then we know that AC, this comes into picture, capable of industrial application. This comes into picture to understand this. So invention is J. J is for invention. So invention is IA is for international application and J is for invention. Invention is new product or process. Sometimes it may be confusing when they write product and process. So this is a tricky one. We need to understand. Invention means a new product or process involving an inventive step and capable of industrial application. So these are the conditions. And here to mention inventive step. So this is again defined in JA. So J, it is not even K, but JA means this part of this. So they have given JA. Inventive step means a feature of an invention that involves technical advance as compared to the existing knowledge. It means to prove that it is an inventive step, we must show that there is a technical advancement. So we need to compare. We need to give that this is what known in the prior art, and this is what I would say that inventive. I mean, this is a technical advancement over the prior art. So this is not known. Or another is having economic significance. Or even if there is a not much technical advancement, but if we can show or if you can demonstrate that this is not very technical, but it has a very economic significance, then also it will be called as inventive step. But that means it seems like obvious, very new, but no one has done this. And because we did this first time and we are getting a huge economic significance, so therefore it can be considered as inventive step or both. That means there is a technical advancement and there also economic significance or both. And that makes the invention not obvious to a person skilled in the art. Okay. So if it is obvious, so this inventive step is a very tricky one and it always involves arguments, then lot of hearing, um, patent agents, attorney, and the inventor, they fight over it and they try to prove that what is a technical advance if it's not very clearly mentioned. And also they try to justify economic significance. And they would say that this is not obvious to a person skilled in the art. So inventive step. Legal representative. Okay. So if you just remember, we read about this legal representative in the case of assignees. So subsection 2, subsection 1, assignee, it says that assignee of the assignees and the legal representative of the deceased assignee. So this word legal representative, it requires explanation. So legal representative is given in K, I1K. Means a person who in law represents the state of a deceased person. If a person is for the deceased person, who in law represents him is called a legal representative. And there's also called new invention. What is new invention? So invention must be a new product or process. So what is new? So that is defined in L. New invention means any invention or technology which has not been anticipated by publication in any document or used in the country. You see, it is mentioned not published. Publication is not published. It is not used in the country. In the country means India or as well in the world. So it also covers within India and outside India before the date of filing of patent application with complete specification. So there are different types of application. One is provisional and one is complete. So when we are going to file the complete specification, okay. So before the date of filing the patent application with the complete specification, there should not be any publication or the evidence of use that is subject matter has not fallen in public domain or that it does not form part of the state of the art. That means it is not known, it is novel, it is not published, it is not used, people they do not know about it, there's no written document, any proof about it existence, then it is called a new invention. Okay, L. And then LA, opposition board. So opposition board is formed when there is an opposition. So there are pre-grant opposition and post-grant oppositions are there. Constitute under the subsection 3 of section 25. So when we read opposition, pre-grant and post-grant opposition, we will read about opposition board. So this opposition board is refers to section 25. Patent. What is patent? So 1M, patent means a patent for any invention granted under this act. So if it is granted, then it is called patent. And who is called patent agent? N. A person for the time being registered under this act as a patent agent. So if he's registered under this act, he is called patent agent. And if even if he has passed the exam, he was once registered as a patent agent, but if somehow if his name is not there in the register, then he's not called as a patent agent. For the time being, when the person is applying or acting on behalf of patent agent, at that time he must be a registered patent agent. That means then only he is called patent agent. Patented article and patented process. What is the meaning of patent article and patented process? Very simple. Means respectively an article or process in respect to which the patent is in force. So to say my article is patented or my process is patented, the patent must be in force. That means it must be patent, it must be a granted patent, then only we can say it is a patent article or patented process. Sometimes they write patent pending, they mention, but they cannot say patented. If you say patented, then we are violating this, and you will see what are the consequences if the process or product is not patented and we say it is patented. So it is clear. It must be a patent is in force. Then OA, PCT, Patent Corporation Treaty. What does this mean? So we just learned about the PCT in case of international application, IA. International application means an application for patent made in accordance with the Patent Cooperation Treaty. And what is this Patent Cooperation Treaty? Patent Cooperation Treaty means which is done at Washington on 19th June 1970 as amended and modified from time to time. So first time it was done in Washington on 19th June 1970, and thereafter it may be amended or modified, but the date remains the same. So we have two dates to remember. One date is for Patent Cooperation Treaty, PCT, that is 19th June 1970, and one was for the Budapest, 20th April 1977. So first was the PCT 1970, and the second was on for the Budapest 1977, after 7 years. So I'm just saying 7 years and before and after, so that it helps to memorize this. So Budapest was after BCT, 1977, and June, and this was in June, 19th June, and that was on 28th April 1977. So these 2 dates, Budapest date, Budapest Treaty, and the Patent Cooperation Treaty at Washington. And Budapest Treaty was, of course, on Budapest. So these things we need to have remember. Then we have the patentee. T means the person for the time being enter on the register as a grantee or proprietor of the patent. So he is called patentee. So whenever the word patentee is mentioned, patentee means it is a granted patent, then they are called patentee. And then there's word called assignee. Assignee means person include assignee of the assignee of the legal representative of disease assignee, and reference to the assignee. Any person include reference to the assignee of the legal representative or assignee of that person. So those are called assignees, and there is called patentee. Patentee means always this is the granted patent, and if their name is mentioned, then they are called patentee. There is also patent of addition, means a patent granted in accordance with Section 54. So we can always file a patent of addition, and there are certain advantages and disadvantages. These are mentioned in 54. We'll discuss during that. So patent of addition means a patent granted in accordance with Section 54. Patent office, very similar, Section 74. And person includes the government. Okay. So whenever I say person, person doesn't mean one single person, but if it is mentioned a person can do this in this patent act, it means the government is also included as a person, and government can also do. So there is a difference between person and person interested. So many times we'll see that who can oppose, who can do this. So sometimes it is written that a person can do this, and sometimes it is written that okay. So person includes government, and T subsection 1 of T, person interested, means includes a person engaged in or in promoting research in same field as that to which the invention relates. So this person, two types. If he's engaged in the research, he is a scientist engaged in research, or is promoting the research, means it could be a company who are funding, who are working on the research, or a scientist, or a person in the university who are doing the same field. This is important. Same field of the invention to which it relates. So this is the idea. So whenever we see a patent application, it will be written that this invention relates to. So that is very important. This invention relates to. So whenever I see that a person whose activity or whose research also relates to the same field, so those are person are called in person interested. So any person cannot do that activity if it is written that person interested. So person and person interested will keep hearing this word at many times in the subsequent sections, and therefore it is very important to remember this. And also it comes in exam or also in interviews, and it's very important. Pharmaceutical substance means any new entity involving one or more inventive steps. Okay. And prescribed. So many times you will see this word prescribed. What is the meaning of prescribed? You will see prescribed, as given. So prescribed means in relation to proceeding before High Court. So prescribe are rules made by High Court. If so, prescribed means if it is before High Court, then the rule of High Court will be there. and B in relation to proceeding before appellate board, then rules appellate board. So now this appellate board is doesn't exist. So this is not there. And in other cases, prescribed means rule made under this act. So sometimes it may be said as prescribed. So whenever it says as prescribed, means we need to look into the rule, act and the rule, and then see it could be prescribed means the time or fees or the manner in which it need to perform. So these are mentioned. So whenever we say as prescribed, and then we need to refer which rules and which act, which section, which subsection, what this talk about this the process. So prescribed means that. And prescribed manner. So when it says prescribed manner, then it includes the payment of prescribed fees. So prescribed means as prescribed, means process, all other things by rules. And if it says prescribed manner, then it includes the prescribed fees. Okay. And the priority date. Priority date has the meaning assigned to it by the section 11. So section 11, we'll see what is the meaning of priority date. And the register. Register means the register of patent referring section 67. So now you can see that it is very important that we remember all the section and what do they mean. And this will help in understanding and reading all the sections in subsequent part. True and first inventor. Okay. So you will hear this word also. We will read this word true and first inventor. So patent is granted to the true and the first inventor. So true and first inventor does not include. So it is not talking about what includes, but it says does not include either the first importer of the invention into country, I mean India, or a person to whom an invention is first communicated from outside India. So it does not say what includes true in the first inventor, but it says what does not include true in the first inventor. Okay. So true in first inventor, by the meaning of the word, we can say that the person who invented the first and who filed the first. So we can discuss more about it, but true in the first inventor, according to definition, it says what does not include. It says does not include either first. I mean, if I say that I was the first importer, I didn't work, but I did not do R&D or I did not manufacture. I didn't. This is not my idea, but I imported the invention into India, or somebody from outside some told me about this. So it doesn't mean that I become the true and the first inventor. And then last for this section, uh, section 2, this section 2, definition and interpretation, and subsection 2 in this act, unless the context otherwise requires any reference. So unless the context otherwise requires. So this is the double negative sentences. To the controller shall construe as including a reference to any officer discharging the function of controller in pursuance of section 73. So it means that in this act, any reference to controller also includes if the controller is assigning somebody else. So if the controller is not doing by himself, but he will be assigning an officer to discharge the function, then we will have to take it as if controller has done the same task, unless the context otherwise requires, unless it does not say like that. To the patent office shall constitute or include as including a reference to any branch office or the patent office. It means that whenever it says patent office, it also includes the branches of the patent office. That's very simple to say. But it says unless the context otherwise requires. That means if the patent office does not include any branches, then it has to be mentioned specifically that this patent office does not include the branches. And controller, you need to write that this officer is not acting as controller. It has to mention. If it is not mentioned like that, then controller also includes any officer who is discharging the function of the controller. Okay. So thank you very much. So if you would like me to read the entire sections and the entire rule in this manner, let me know in your comments, and then I would make more. I will do more reading for you so that it will be helpful for you for the pattern as an exam and thereafter as well. Thank you very much.